This is Kathy Humbarger in the studio with you today, and our guest is Jim Holden, attorney and member of the Indiana Right to Life Board of Directors, helping us understand the court system and how it impacts our fight for life. Jim, we've referenced Supreme Court appointments and judicial appointments in our conversation, and those appointments, especially at the Supreme Court level, get a lot of media attention. Help us understand why the courts are so important to us as pro-life advocates. After a bill becomes a law, how do the courts get involved?
Well, in this case, obviously the Roe decision is what started our country down the wrong path in this area and created the need for pro-life activism at this level, unfortunately. So the courts are fundamentally important to this fight. And courts are nothing more than collections of judges people have been appointed to the bench. And so I think as members of the public, it's important for us to scrutinize very carefully at all levels, but particularly at the U.S. Supreme Court level, the kind of jurists that end up getting appointed. And I think the Kagan nomination right now is putting a lot of spotlight on that.
Let's talk a little bit about Supreme Court nominee Elena Kagan. There are several pro-life leaders who are very concerned, among them Sharman Yost, the president of the Americans United for Life, Wendy Wright, the president of Concerned Women for America, Marjorie Dannenfelser, the president of Susan B. Anthony List. Are you concerned?
Absolutely. I'm definitely concerned. Now, it's true that because Ms. Kagan has not been a judge in the past, there's no judicial paper trail, if you will. In other words, she's not had to rule because she's not been a judge on issues affecting life. But I think we can still glean a lot from her writings and certainly the company she keeps.
We have more than the Kagan appointment that we're looking at. I understand there's an opening in the Indiana court system as well. Could you talk a litlittle bit about that?
Certainly. It's obviously getting a lot less attention in the media, but a longtime member of the state Supreme Court here in Indiana, Justice Bohm, has announced that he's retiring a couple years short of his mandatory retirement age of 75. Currently, the five-member state Supreme Court has 2 Republican appointees and 3 Democrat appointees. This vacancy will give Mitch Daniels, who's obviously a Republican, an opportunity to tilt that balance in favor of the Republican side of the aisle because Justice Bohm had been a Democrat and arguably one of the more liberal members of the court, certainly one of the most, if not the most, pro-abortion justice. So I think it's a real opportunity for Governor Daniels to tilt the ideological split of the court to the right and hopefully towards our side as well.
And how does that procedure work, Jim?
It is a little different than the nomination and confirmation process at the federal level. The main requirement, of course, is that the individual has been an attorney for a certain number of years. But other than that, the process is pretty set. It's set in statute that the applicants, which can be anybody in the state of Indiana who is an attorney, apply and are screened by the Judicial Qualifications Commission, which is made up of the Supreme Court Chief Justice and 4 other members appointed by the governor. Those people on the Judicial Qualifying Commission screen all the applicants that apply, and they cull that list down to 3 top candidates that are then presented to the governor, and he has to pick among those 3. Now, the other difference is there's no confirmation process. In other words, the state Senate or state House does not have to vote to approve the governor's choice. The governor simply picks from one of those 3. And that process was put into effect some years ago to supposedly depoliticize the choosing of Supreme Court justices. Some 40, 50 years ago in Indiana, Supreme Court justices actually ran for office on partisan ballots, and there was a trend towards depoliticizing the judiciary. I'm not sure that it's entirely worked, but that's the process that we have.
So our listeners, citizens across the state, really don't have much input into that process. Is that right, or is there anything they can do to influence this?
It is somewhat removed from the public, and that's some commentators think that's a good idea. There's certainly downsides to that. I think when the process reaches the point where the 3 individuals have been recommended to the governor, I think that would be an opportunity for the public, including groups like Indiana Right to Life to indicate their preference to the governor. But I think that's one of many factors that the governor will likely take into account when making his final decision. But it would be probably the best time for the public to indicate a preference.
And how long will that take before we know who those three nominees are?
It will likely take a period of months. I don't think
Okay.
it's anything that's going to happen quickly.
Okay. And to our listeners, we'll make certain that you get that information at the proper time. So if there's anything that we can do to make certain that our voices are heard in that arena, that would be another opportunity for us to do that. Jim, I know our listeners, like me, have stood in the voting booth in past election cycles, and we see a judge's name on the ballot and we vote for retention. Are these judges, like the one that the governor is going to appoint shortly, are they then on the ballot for us to determine if they stay in their role, or is that a completely separate set of judges?
All appellate-level judges in the state of Indiana, which could be the Indiana Court of Appeals, the tax court, and the state Supreme Court, appear on the ballot periodically for a yes-no retention question. And that's the public's opportunity to say, yes, we want to keep this judge, or no, this judge should not continue. The governor should appoint someone new. Now, I can't recall ever seeing a situation where a judge was not reappointed by the public. In other words, they usually win at least 60-40 yes vote. But that's not to say that the public couldn't turn a judge out. As you know, also, the trial court judges are still chosen on a partisan ballot in the fall election. In other words, they run as Democrats or Republicans at the county level. But yes, you're right, the Supreme Court and state appellate justices are subject just to a yes-no retention question. And if I could point out something, too, that I think might be interesting to your listeners, they may or may not be aware of some litigation that's currently going on. As you mentioned, when you stand in the voting booth, and I think most people would agree with this, many times you don't really know a whole lot about the judicial yes-no questions, or even about some of the justices or judges who are running on a partisan ballot at the county level. And I think one of the reasons is because the canons of judicial ethics really restrict what a judge can say about his or her views on issues like abortion. And for instance, when Indiana Right to Life mails out its annual survey to political candidates, the results of which ends up making public, those judges are under an ethical duty, according to the state Supreme Court, not to answer those questions and indicate how they feel about issues like abortion. And I think that does the public a disservice. So I know that Judge Serto in the Marion County Superior Court and another judge from northern Indiana are involved in some litigation against those judicial canons, and fortunately are being represented by Jim Bopp, the attorney from Terre Haute, who's well known in the pro-life community, and they're trying to strike down those canons so that judges can actually indicate to the public how they feel about issues like that.
And we're looking forward to the decision in that case, because I think all of us want to be informed voters and have all the information that's available to us. I know Indiana Right to Life does a great job of looking over past decisions and trying to get that information out prior to Election Day so that at least we know what decisions have been made by these judges, because up until now, we've been pretty much flying blind on this particular issue. So I think, Jim, what we're seeing is an awakening of our citizens across the country on a variety of issues. And I think the court appointments, the court retention votes, and the decisions that judges make after they're appointed are receiving more attention by those of us particularly who are passionate about the life issue. And I think that's a healthy thing and long overdue.
Indeed, I think it's a great thing.
Well, we appreciate so much your time, Jim, and your expertise. Will you come back and talk with us about those three nominees as the time draws near for the governor to make his appointment and bring us up to date on other legal matters?
Absolutely. I'd love to do that.
Well, we appreciate again Jim Holden being with us today, Indiana Right to Life board member and attorney and advocate for life. Jim, the Lord bless you as you continue to stand for life where He leads you.
Thank you, Kathy.
You've been listening to I Choose Life Radio Magazine. If you have questions about this program or if you would like to support the fight for life, please call Allen County Right to Life at 471-1849 or go to IChooseLife.org, because without the right to life, no other rights matter.